Hello, welcome everyone to today's webinar session on demystifying labor codes. We are delighted to have Mr. Vardhan sir, who has taken care of Aparajitha's labor laws and strategic compliances. He is a chief consultation officer here, and he has played a key role in shaping the organization's flagship compliance management services since 2005, bringing unmatched clarity and practical insight to the discussion. Before starting the session, I would request everyone to post their questions in the chat box. We will address them after the session gets over. I now ask Vardhan sir to enlighten us.
Yeah, thank you, Shreya. Just to confirm whether the screen is visible.
Yes, sir. The screen is visible.
Yeah, so I can go ahead, no?
Yeah, but if you can just slide share, so the main screen only will be seen.
Since slideshow,
Okay, we can see the next slide also. That's why I asked.
Is this all right?
Completely fine. Yes, sir.
Yeah. Thank you. Thank you. Yeah. So thank you very much, Shreya, for that introduction. Hi, everyone. Very good afternoon. I think the industry is now is buzzed with the word labor codes. Many of you are aware that the code on wages was first introduced sometime in 2019, and the other three codes were introduced in 2020. Then subsequently, I think because of the pandemic, I think we were all probably were not able to physically attend office, but we were able to at least connect online. And particularly during that time, in fact, we were able to discuss, we were able to conduct a lot of sessions on probably on the labor codes, which were just passed in both the houses of the parliament. And of course, it took a long time of almost 6 years for it now for implementation, thanks to the government of India and all the other stakeholders. But yes, though the 4 labor codes have been introduced, still we are waiting for the implementation of the corresponding rules, be it the central rules or other appropriate governments, state governments rules, right? And the messages, it will take another 1 to 2 weeks for those rules to get completed, and again that will undergo a process that will be kept open for objections or any suggestions, and that will be there for 45 days. Then subsequently, after considering all the suggestions, the government will once again have to implement the rules. That will take another 45 to 50 days. So roughly this will take another 3 to 4 months for implementing the corresponding rules.
Vardhan sir,
yeah.
Apologies, sir, for interrupting. I think a few of them are having speaker issues, voice issues. Everyone, if you could set your mic, go to your mic settings, click the drop down and enable speaker. Some of you might have a default speaker as off, which is why all of you are facing speaker. You're not able to hear Vardhan sir speak. If you could just go to your settings, mic settings, and click, like enable, like click on your the mic button there. You'll be able to hear, and you'll enable the voice, so you'll be able to hear Vardhan sir speak. Okay, thank you so much. Please continue, sir.
Yeah. So I'll wait for half a minute. so that everyone is ready, no?
Sure, sir. Everybody just please put a thumbs up so that Vardhan sir can hear you, know that you're, yeah, okay.
Right, okay. So again, I'll proceed. So yes, the codes are now enforced and it has come into force from 21st of November 2025. And just to trace the background, we all know that the economic reforms happened sometime in 1991, the liberalization, privatization, and globalization. And since that time, in fact, the industries have been asking for the corresponding labor reforms. Unfortunately, for the next 10 years, there was no move. Sometime in 2002, I think the second National Commission on Labor that was formed. And after doing the study, they submitted a report finally suggesting to come up with 5 codes instead of the existing set of labor legislations. The recommendations were given as early in 2002, but again in 2004 the political situation changed. Then for the next 10 years there was no move on this front. Then again from 2014 this got momentum, and the first code on wages that was released in 2019. Then in 2020 the other 3 codes, the Occupational Safety, Health and Working Conditions Code, the Social Security Code, and the Industrial Relations Code. All the 3 codes were introduced, but we were waiting for the notification regarding the date of implementation. Only now we have got it actually. Right. So the idea is to amalgamate the existing set of laws, to simplify, to rationalize. Right. So this is the main idea again. And through the introduction of codes, the government is planning to leverage on the technology so that we will have more transparency and more accountability. And the codes would also are expected to widen the scope, right? Which means the purview of the act will get expanded, and social inclusion is also there. Like you all know, again, we have a 60 crore roughly workforce in our country, and the set of labor laws that impact only the 10% of this workforce, that is roughly 6 crores. Rest of the 54 crore, they are actually not falling under the purview of these labor laws. They will not get the protection under these labor laws. But now attempt is made to include people in the unorganized sector also, the platform workers, the gig workers also, at least from the social security perspective. And these measures should ultimately usher in the compliance culture. And the ultimate idea is to do ease of doing business, to set up more enterprises. That I think these moves should attract more investment, FDIs, and ultimately this should generate employment also. So this is the quick background with which I think the codes are introduced. And yeah, what you are seeing on your screens is the 4 existing legislations: Minimum Wages Act, Payment of Wages Act, Payment of Bonus, and Equal Remuneration. All these 4 now getting subsumed into one code called Code on Wages. And now, though there will not be any separate legislation called Equal Remuneration Act or Minimum Wages Act or Payment of Wages Act or Payment of Bonus Act from 21/11/2025, the concept will continue. The idea will continue. The idea of equal remuneration, the idea of minimum wages, the idea of payment of wages, the idea of bonus, that will continue, right? Now, instead of being a separate legislation, these are all made as one chapter, right, in the code, actually. That is the idea. So the simplification is done without compromising on the spirit of it, right? So that is the idea. So what you are seeing on your screens is probably on the first chapter, you can see equal remuneration. I have put it in red font. Similarly, the second chapter, third chapter, and fourth one, right? Other items are common for all these four areas now. That is how it is. Similarly, the second code is the Occupational Safety, Health and Working Conditions Code. And we have the 13 labor legislations. The list is there on your screens, and that is those legislations are getting subsumed into one code, right? This was introduced in 2020. Then, yeah, these are all the chapters now under the Occupational Safety Code. And I would like to draw your attention to Chapter 11, which is in red font again, special provisions for contract labor, ISMW, etc. On your right, Chapter 11, it is further subdivided into various parts. The part 1 will deal with contract labor, ISMW. Part 2 is on audiovisual workers. That is the current cinema workers are now called as audiovisual workers. So instead of the Contract Labor Act, which is earlier before 2111, which was there as a separate legislation, now it has become one part under Chapter 11, under the Occupational Safety Code. That is how it is going to be. Then part 3 is mines. Part 4 is BD and cigar workers. Part 5 is building and other construction workers. And part 6 is the factories. And the next code is the Code on Social Security that encompasses the 9 legislations, starting from the Employees Compensation Act, 1923, till the Employment Exchanges Act, right, 1959. Then this is how the chapters are arranged under the Code on Social Security. Again, whatever is there in the red font, PF, it will not continue as a separate legislation. Instead, it will continue as Chapter 3 in Code on Social Security. So 3, 4, 5, 6, 7, 8, 9, and 13. 13 is the current Employment Exchanges Act, right? The employment exchanges would now be known as career centers, right? That is how it is. Yeah, and finally, the Industrial Relations Code, which will encompass 3 legislations: the Trade Unions Act, the Standing Orders Act, and the Industrial Disputes Act 1947. And yeah, so this is how it is. So to summarize, instead of the 29 separate legislations, now it would become just 4 codes. And whatever changes happening, this is only in the central sphere, right? So only the central legislations, 29 central labor legislations, are now getting merged into just 4 codes. That is the idea. Now, what I'll do is there are various types of changes proposed under the codes. The most significant one is the change in the definition of the term wages, right? So probably again, there is a cap which is brought in for the allowances portion, the exclusion portion in the normal monthly wage structure of an individual employee. It cannot go beyond 50%. There is a cap now. It was not there earlier. So this single provision, this single change which is brought in through the codes, that is likely to make a huge impact. So I'll try to explain the definition of wages alone, and subsequently I'll try to come up with some sample salary structures. So how this will work once the codes come into full force. Yeah, it is already there, but still. So I will harp on the wages portion for some more time. Subsequently, in fact, I will be highlighting only the key changes which are brought in through the codes. So more I'll highlight. I will discuss on the highlights only. Right. I'll move on. So the wages definition goes like this. Actually, it has all the parts. It has a substantive part. It has inclusion part. It has exclusion part. It has provisos. And so the substantive part says all remuneration by way of salaries, allowances, or otherwise expressed in terms of money or capable of being so expressed as per the terms of employment. So it includes everything. And the specific inclusion is basic, DA, and retaining allowance. When we say retaining allowance, it is more relevant for seasonal industries, right? Where the seasonal industries would pay some amount to the persons during the non-season period, so as to retain them for the next season. May not be this particular component may not be there for many of the industries which are operating on a perennial basis. So probably most of us maybe are concerned more with the basic DA. We may not have retaining allowance for this purpose, right? Then comes the exclusion. We have a lot of components excluded, starting from A to K. So starting from bonus, the value of house accommodation, any contribution paid by the employer to any pension or provident fund, any conveyance allowance, any sum paid to defray special expenditure, house rent allowance, remuneration payable under any award or settlement, overtime, commission, any gratuity payable on termination, any retrenchment compensation. Again, I would like to draw your attention to 4 classes D, F, G, and H, which are in red font. So all these 4 classes would still be considered to be part of wages for the purposes of payment of wages and equal remuneration. For all other purposes, from A to K, it will be treated as excluded components. But only for the purposes of payment of wages, the current Payment of Wages Act, or the equal remuneration, the current equal remuneration. For those purposes alone, all these 4 classes D, F, G, H will continue to be wages. I move on. So the first proviso, it states, provided that for calculating the wages under this class, if payments made by the employer to the employee under classes A to I. So I'll just go back. A to I means up to commission. Here on your screens, you see you can starting from bonus up to any commission payable I. So they have very clearly excluded gratuity J and retrenchment compensation, which is there in class K, right? So it will not be taken into account for even considering the 100% of wages, right? But A to I, yes, it is there. I move on again. So if the total sum of A to I, if it goes beyond 50%, then over and above 50% quantum will be added back to wages. So that is the catch, and the first proviso says about that only. I'll just read it fully for the benefit of all. Provided that for calculating the wages under this class, if payments made by the employer to the employee under classes A to I exceeds 1/2, that is 50%, or such other percent. So central government can change the percentage. Currently, it is 1/2 only, which is 50%. Of all the remuneration calculated under this class, the amount which exceeds such 1/2, so the amount in excess of 50%, or the person so notified, shall be deemed as remuneration and shall be accordingly added in wages under this class. So this particular proviso, I think this will have huge impact. Let us see from subsequent slides with sample salary structure. Then, as I said earlier, the second proviso says, provided further that for the purpose of equal wages to all genders, this is the Equal Remuneration Act, and for the purpose of payment of wages, the emoluments specified in classes D, F, G, and H shall be taken for computation of wage. So only for these 2 purposes, as I said earlier, the components mentioned against these 4 classes would be treated still as wages, right? And finally, there is an explanation where an employee is given in lieu of the whole or part of the wages payable to him, any remuneration in kind by his employer, the value of such remuneration in kind, which does not exceed 15% of the total wages payable to him, shall be deemed to form part of the wages of such employee. So there is a provision to make not more than 50% of the wages in kind, but this is possible only if there is any gazette notification issued by the appropriate governments. So as it is, there is no such notification available. So in fact, today we cannot make any payment in kind instead of wages. So it is to be made only in cash. Yeah, I'll just move ahead with sample salary structures. You can see this is a very simple salary structure. I think the monthly gross of the individual comes to 18,000. So I have kept 18,000 as the 100% remuneration. So the components are basic, it is 6,000, HRA 4,000, conveyance allowance 4,000, and commission 4,000. So if you look at it, the basic portion works out to 33.3% of the total monthly gross. And the house rent allowance, the conveyance allowance, and commission, as we saw earlier, those are all excluded components. So those components will not be treated as part of wages, right? So today, we may, in some of our establishments, this kind of structure, which is all right, right? This is not questioned by any of the authorities. But after the introduction of the code from 21/11/2025, this structure is not in line with law, because the wage portion works out to only 33.3% here. It should be at least 50%. So the excluded portion, it works out to 66.6%, that's 12,000. So the excluded portion cannot go beyond 50%. So in case in any of our establishments, if we have a salary structure whereby the exclusion part goes beyond 50, then probably we may have to think of revisiting our salary structure so as to make the wage portion coming at least to 50%, so that it will be in line with law. In case if we still go ahead with this type of structure after the introduction of code, then the excess amount, right, that is 3,000. 12,000 is the exclusion portion, but exclusion portion cannot go beyond 50%. That's 9,000. So 3,000 is extra there in the excess portion. So that 3,000 will be treated as part of wages. 3,000 will be added to basic, which is 6,000. So total 9,000. So 50% of the monthly gross, that is the total remuneration, that would be automatically treated as wages for any purpose. Not only these 4 areas which are falling under the code on wages, even for other purposes which are covered under the other codes, social security, industrial relations, or the occupational safety code. That is how it is going to be. And the first proviso, I'll just go back to the so here you can see again the first proviso, which puts a cap on the exclusion part. So which is 50%. Exclusion part cannot go beyond 50% in a monthly salary, right? So if it goes beyond, the excess amount will be automatically added to wages. That is how it is. It is better in case if we have for some of the employees wage structure, probably where the wage portion works out to less than 50%, it is better we revisit and make it as 50% at least, right? That will be in line with law. That is one major point. And again, I'll go back to the previous slide from here. So because in the example we saw, I considered the monthly gross, this 18,000, as 100% remuneration. Whereas if I go back to the exclusion part, I think class A and class C, I have made it in the bold format. So it is the class A talks about bonus, which is essentially the annual payment. So normally it will be paid only after the end of the accounting year. And the C class is about the contribution made by the employer in respect of any of the employee towards pension fund or towards provident fund. That is what is mentioned in class C. Actually, people may tend to add these two also to decide on the 100% wages, right? But we cannot practically do that because the is made as per the provisions under the Payment of Bonus Act currently, and after the code it will be under the payment of bonus portion under code on wages. And similarly, the employer's contribution towards PF in respect of an employee will not get reflected in any of the salary registers maintained under the prescribed legislations. So, and it doesn't stop with that. That probably if we go through that class C fully, that will also say the interest accrued thereon. It is not possible to ascertain that amount on monthly basis, right? So for my discussion throughout this webinar, probably this session, I will consider only the plain monthly gross salary as 100%. Right? There is, as I said, there is another opinion that we may have to include that bonus also, since it is coming under A to I classes. Though it is an annual payment that needs to be on a pro rata basis for month, we have to calculate and add. There is an opinion like that. But in my opinion, that is not practically possible, and that may not be appropriate also. Because if you look at class C, which is about employer's contribution towards the PF or pension, it is possible the portion of that amount is actually PF, and you will end up paying PF calculation on PF. I think that cannot be the intention of the lawmakers, and that is the reason I'm excluding A and class C from determining the monthly gross salary, that is the total remuneration of 100%. So let us be very clear on this aspect, because there are other opinions also. But you may, my suggestion would be, please seek your the opinion of your legal counsel before you go ahead. Yeah. Now I'll go to the next sample. Here, I think for some of the categories of employees or workers, the employers would pay mere minimum rates of wages. It is possible, particularly with respect to the contract workers, and it is possible when the casual workers are hired, right? The case one, I have assumed minimum wages as 12,000, and this 12,000 is split up into basic 10,000 and DA 2,000. So the total comes to 12,000, right? And basic and DA, both these components will be treated as part of wages. It's clearly both the components fall under the wage portion. So the entire 12,000 will be treated as wages for any purpose. So this particular structure, this setup, this is all right in line with law under the code on wages. And the second case is, case two is, there is no split up. It is a one consolidated payment, which is made as 12,000. Right. So entire 12,000 will be treated as salary and will be considered for any purpose, be it minimum wages, payment of bonus, gratuity, PF, ESI. So absolutely no issues on case two also, because this has no split up. But when you look at case three, I have put it in red font. It is divided into basic 10,000 and HRA 2,000. Right. So currently, again, there is a practice of employers doing like this. And from minimum wages perspective, this current minimum wages act, this may be all right. But from payment of bonus act perspective, this may not be all right, because bonus is to be calculated at least on minimum rates of wages as per section 12 of the payment of bonus act currently. So this split up may not be acceptable even today. But after the introduction of codes, all the more this is not in line with the new definition, right? Because HRA is excluded. HRA is not considered to be part of wages, but minimum wages here is 12,000. So even if an employer continues with this salary structure, case 3, after the introduction of codes, for this structure, the wage would be considered as only 10,000. So there is a shortage of 2,000. So in case if the authority takes cognizance, then the authority may ask the employer concerned to make good of the balance 2,000 with fine. I think we know how it will multiply, right? So 10 times of the shortage amount we may have to pay. And then in addition, we may have to pay the penalty, which will be decided by the appropriate authority. So the third split up is not possible, is not in accordance with law as per the new definition of the term wages. So this is particularly with respect to persons who are getting mere minimum rates of wages. I move on. Yeah, this is also with respect to minimum wages, but it is not mere minimum rates. It is more than minimum wages, right? So the monthly gross, it is coming to 12,000. The assumption here is minimum wages is 10,000. For this slide, the assumption is minimum wages is 10,000. The basic is 6,000, DA 3,000. The total comes to 9,000. HRA is not considered to be part of wages as per the new definition. So for this structure, after the introduction of codes, the amount paid as wage would be considered as only 9,000. So there is a shortage of 1,000. It may be all right. Again, this structure may be all right for current situation prior to the implementation of code, but not now, right? So this, whoever has this type of structure in your establishment, you may have to think of revisiting the salary structure. I move on. Again, this is another wage structure. The monthly gross comes to 32,000, where the basic and DA, the wage portion, works out to 14,000, 10,000 plus 4,000, right? There are three allowances part, HRA, conveyance and commission, and the allowances part comes to 18,000. 18,000 is more than 50% of the monthly gross, so which is not acceptable. So for the purpose of bonus, again, the wages should be 16,000 at least. So basic and DA should work out to 16,000 or more than that. Only then this structure would be considered to be a correct one. Right, okay. So whether it is 14,000 as we assume as per prior to the court's situation, or after courts it is 16,000, both are less than 21,000, then this person will become entitled for bonus, but calculation will be made on 7,000 or minimum rates of wages applicable to that. So there is no implication with respect to the calculation, but the quantum of wages would vary. Instead of 14,000, it will be considered as 16,000 for this structure. I move on. For ESI, again, I've come up with two samples. So basic DA and HRA, monthly gross is 24,000. All these three components prior to introduction of codes are considered to be wage part for the purpose of ESI, because HRA is treated as part of wages for ESI. So since the quantum is 24,000, it is more than 21,000, which is the ceiling for ESI. So this person will go out of the purview of ESI. This person need not be brought under ESI. He will go out of it. But after implementation of code, since HRA is not treated as part of wages, the quantum will become automatically 18,000. Which means which is less than 21,000. So this person needs to be covered under ESI, and the contributions both by the employer and the employee concerned have to be made. Right. So that is the change in case for this particular salary structure. And on the right side, sample 2, again, three components, 8,000 basic, 4,000 DA and HRA 4,000, total comes to 16,000. This is as per the ESI Act, it is less than 21,000. This person needs to be covered under ESI, but the contributions will be made on the entire 16,000, right? But after the introduction of codes from 2111, the quantum of wages is only 12,000. HRA will not be treated as part of wages. So this person will continue to be covered under ESI, but contributions are to be made only on 12,000. So the quantum of contribution for both employer and employee will become less. So that is the implication for this salary structure. I move on. Now it is about gratuity. Again, the monthly gross is 30,000. Basic and DA works out to 10,000 plus 2, which is 12,000. But the allowances portion comes to 18,000. So this goes beyond 50%. So this is not acceptable salary structure for the purposes of gratuity even. Currently, yes, we would calculate gratuity only on the 12,000 basic and DA, sum of basic and DA. That is also all right. But after the introduction of codes, I think for this salary structure, we may have to calculate gratuity at least on 15,000, which is considered to be 50% of the monthly gross total remuneration. So this is how the impact is going to be with the change in the definition of the term wages. I think I take some time to explain the definition of wages with the samples, because this will have implications. So it will not just stop with, I think I discussed from the perspective of some 4 or 5 areas. You may have impact with respect to calculation of overtime. you may have impact with respect to calculation of leave encashment also, and other aspects, right, like Maternity Benefit Act and other areas also. But these are all key areas which I thought I could highlight so that it will be taken care of by you once you go back to your establishments. Now, specifically, the key changes. See, again, I will not be in a position to touch upon all the provisions of the entire 4 codes, but what are all the key areas, key changes with respect to the existing position, right? So this is very specifically regarding the minimum wages. Again, you may all know that the Minimum Wages Act will be applicable to the scheduled industries. So there is a schedule attached to the Minimum Wages Act. Only those industries which are involved in that, probably those industries list is there in the schedule. Only for them, the Minimum Wages Act is applicable, right? But after the introduction of codes, it is not limited to any specific list of industries. It will be applicable to all industries. Again, I repeat, minimum wages portion under code on wages will become applicable to all types of industries. It will not be limited to any specific type of industry, right? That is going to be, again, major change. So the scope of this applicability is widening, actually. I think we saw that earlier also. And floor wages, yeah, there is a concept which is introduced called floor wages. This will be fixed by the central government. And the appropriate governments, which means central government as well as various state governments, they will continue to have the powers to fix the minimum rates of wages. But the catch is the minimum rate shall not be less than the floor wage fixed by the central government. Again, I repeat, the floor wage will be fixed by the central government and it will have a statutory mandate. The minimum rates of wages to be fixed by the central government and other state governments as appropriate governments cannot be less than the quantum fixed under floor wage. And the floor wage need not be one quantum. It could vary from one region to another region. It is possible, right? So that is another change. So I think this is there in section 9 under code on wages. Then yes, we saw HRA is not part of wages. I think under the definition of wages, you can see HRA is excluded. Another important aspect is this definition of wage is not only for code on wages. It is equally applicable for other codes also. So again, the terminology will have the same definition for all purposes, right? That is how it is going to be again. And no employer shall pay to any employee wages less than the minimum rate of wages notified by the appropriate government. Assume that for me, the gross salary is 10,000. And the 50% then works out to 5,000. And only 50% is the wage portion. So it is 5,000 actually. But minimum rate of wages for me is 6,000, right? So then I think the employer has to revisit the salary structure and may have to increase the wage portion of my salary to at least 6,000. Which means whether it is 50% or 60% or 70%, the wage portion, it should also be more than the minimum rates of wages applicable to that employee concerned, right? So that is the idea. So these are all certain key points with respect to minimum wages. And next comes the payment of wages. Again, section 1(6) of the current Payment of Wages Act, I think it excludes persons who are drawing more than 24,000. 24,000 is gross salary. So whatever records we maintain under Payment of Wages Act, we will not include those persons who are drawing more than 24,000, right? But this salary ceiling is now removed under the labor codes, which means irrespective of the quantum of salary a person is drawing, all the persons will be considered as employees for this purpose. So I think whenever you maintain registers or any type of record, even returns, you may have to include all the employees in our establishment. So the count, yes, you have to consider all the employees. It is not now subject to any salary ceiling. Then gratuity, yes, we already saw it is very clearly excluded. Even for determining the 100% remuneration, you need not consider, right? Because I think it falls under class J. You need not consider gratuity, because this is because we have a judgment given by the Madras High Court in Madras Fertilizers case, holding gratuity to be part of wages. Yes, and that is the reason if the contractor fails to make gratuity payment to his worker, the liability passes on to the principal employer. But this is only in Tamil Nadu because of this judgment given by the Madras High Court. But now, since the definition itself is very clearly excluding gratuity from wages, I think that judgment will no more be valid actually. And the next point on your screens, wage settlement to be made within 2 working days after the date of relieving of any employee for that matter. Even today, that is the position, but this will not be applicable for resignation cases. But after the introduction of courts, even for resignation, the settlement, wage settlement is to be made within 2 working days. Again, 2 working days means after the actual date of relieving. Then I think every company will have at least 1 month notice period. So we may have to stringently follow the process of people who are resigning to serve the notice period. Only then we will be ready with making this settlement within 2 working days after the actual date of relieving. And the next point is the time limit for payment of wages. If there are more than 100 employees in an establishment, then the payment can be made on the 10th of the subsequent month. So 10 days after the end of the wage period. And in case if there are less than 1,000, then the payment is to be made within 7 days. I think that class is getting removed in the current code. Instead, irrespective of an establishment, whether they have 1,000 employees or less than 1,000 employees or more than 1,000 employees, the payment is to be released on the 7th day. So the 10 days time no more will be available for the employers. So it should be done within 7 days. And the total deduction from the salary of any person for any wage period cannot exceed 50%. Right. So currently, again, in case if a deduction goes towards the cooperative society, partially or fully, this can go up to 75%. Right. Normally 50%, but if the deduction towards cooperative society is there, then it can go up to 75%. But after the introduction of courts, it cannot go to 75%, even if they have deduction towards cooperative societies. It should be restricted to 50%, which means at least 50% of the monthly wages should go as take-home pay, net pay. Then I think certain points with respect to payment of bonus. So this will continue to apply to establishments which engage 20 or more employees. And the act will continue to apply subsequently, even the threshold number falls below 20. But that it is specifically mentioned under the Payment of Bonus Act, but under the codes, this is not there. No mention about the continuity of application if the threshold falls below subsequently. But actually, the fact would remain that they would still continue to apply only. But I'm just bringing to your notice this particular class, whether it is, which is present in the Payment of Bonus Act, it is not there under the codes, section 41(2). Then again, for a person to become eligible for payment of bonus, his salary should be 21,000 or less. It cannot be more than that. If an employee gets more than 21,000, then he will not be eligible for bonus under Payment of Bonus Act. And that is only for eligibility, but for calculation purpose, it can be restricted to 7,000 or the minimum rates of wages applicable to that person, which is higher. Right, but the ceiling, either for eligibility or for calculation, it is not going to be common, and the powers are now vested with the appropriate governments. So the salary ceiling for eligibility or salary ceiling for calculation or for both can vary from one state to another. That depends upon the notification to be issued by the appropriate governments. Right, that includes again central government. Then the bonus is to be paid only by giving bank credit. So no more cash payment would be allowed after the introduction of codes. And there are certain factors for which the payment of bonus can be withheld for an employee, like if he's indulged in some disorderly behavior causing loss to the company, like that. In addition to that, the conviction for sexual harassment, then for that person will also become disqualified for payment of bonus for that accounting year. Right? So this is in addition to the causes which are there currently under the Payment of Bonus Act. So this is the change with respect to payment of bonus, and specifically with respect to contract labor in relation to wages again, right? The regular, see, there are two things. When the contractor undertakes a job from the principal employer, he tries to fulfill his obligations by engaging two types of employees. One is his own employee, because in most of the cases, the contractor happens to be a legal entity, a company per se. So he uses his own employees. In addition, he is also hiring people specifically for the purpose of that project, right? So whoever is hired specifically for that project, they are only treated as contract labor. That is the technical legal position also even today. But fortunately or unfortunately, both the types of workers are considered to be contract workers, and that is how the registers are also maintained by most of the employers. But clarity is given under the codes, which very clearly excludes the regular employees of the contractor. So only those who are hired specifically for the purpose of that project, right, they alone will be treated as contract workers. The regular employees, regular workers of the contractor, even if they are used, their services are utilized for some project, they will not be treated as contract workers. And the company shall pay, that is the principal employer, shall pay to the contractor before the contractor makes the payment of wages to his workers. Now, the consideration to the contractor, it is made probably even after 2 months or 3 months. So, but the contractor has to disburse salary to his workers on a monthly basis. Right. So the idea of the entire contractor and contract labor arrangement is the contractor is not considered to be the employer for the entire establishment. So he has to make the payment of wages to his workers only out of the consideration he receives from the principal employer. Practically, that is not happening nowadays. But through the codes, but it is not exactly under the code. It is under the draft rule. It very clearly says the principal employer shall disburse the monthly consideration to the contractor to enable him to make the payment to his workers in turn. That should be done again by him within 7 days, because the contract workers are also entitled to get the salary before 7 days. And in case if the bonus is not paid to the contract worker, the principal employer will have the liability. The contractor has to pay. If the contractor does not pay, at least for the minimum bonus, 8.33%, the principal employer will be held liable. And the contractor is now included in the definition of the term employer specifically. Again, when I say he will also be treated as employer, it is only with respect to the persons mobilized by him, right? Not for other purposes. So he is not in any way involved or responsible for the business of that establishment. So he is an employer only with respect to employees mobilized by him or workers mobilized by him. Yeah. I move on. So these are all some common points under code on wages. There is a term employee and simultaneously worker is also there. Both the terms are defined. Yeah, so the difference is here. In the intersection portion, you see the skilled, unskilled, manual workers, operational, technical, and clerical employees. So those categories of employees, those persons are considered to be both workers as well as employees. They are falling under both the definitions, right? But on your right, under worker definition, if a person is doing a supervisory job, but if his salary is less than 15,000, he will be considered as a worker. In case if he is drawing a salary of more than 15,000, then he will be treated as employee. He will not be considered as a worker, right? So the salary cap is there only for those persons who are undertaking supervisory jobs, not for others. and working journalists and sales promotion employees are considered to be workers. And on your left, you can see, I'm not very sure, again, I have put it as semi-skilled because under the definition of the term employee, the semi-skilled workers are included there. In my opinion, that should come in the intersection portion because the skilled workers are there, unskilled workers are there. Semi-skilled should fall in between, right? But it is not there in the worker definition. I'm not very sure whether it is a miss or it is consciously done. I'm just bringing this to your knowledge. Then whoever is doing managerial job, doing managerial job, and whoever is doing involved in administrative jobs, those persons will not be considered as workers. Yeah. Then period of limitation is 3 years for any client. In case of any shortage of payment, whether it is minimum wage or payment of wage or bonus or equal remuneration, I think within 3 years, the claim is to be made by the employee concerned. Right now, the period varies between 6 months and 2 years for various different purposes, but it is just made as 3 years for any purpose. And it will be a web-based inspection scheme. Scheme is to be introduced till after the introduction of codes. And the inspectors will now be considered as inspectors come facilitators. So they will first facilitate the employers as well as the workers, particularly with respect to compliance. And first time, in fact, they will also guide. They will not straight away go for a prosecution in case if there is any deviation or non-compliance. But for subsequent time onwards, if there is deviation in whatever obligation to be done by the employer, then he can go in for prosecution. And in case of any complaint, the court can take cognizance directly from employee and the registered trade union. Currently, it is not so, right? But now even the employee of the establishment, if they can straight away make a complaint. And in case of any dispute, the burden of proof will lie with the employer to prove that. And the geographical areas would be classified as metropolitan, non-metropolitan, and rural areas. It is purely based on the population. Metropolitan means it is the area if it has more than 40 lakh of people. Non-metropolitan is between 10 lakh and 40 lakh. Less than 10 lakh, that area would be treated as rural area. This is coming under the rule. Of course, the rules are yet to be released, but still. And the undisbursed due, the unpaid accumulation, I think the employer can hold it for 6 months. After that, he has to deposit it with the authority concerned, right? Then who will in turn arrange to deposit, make the payment to the deceased employee or to his nominee, whoever is there, or the legal heir. And yes, of course, there is an increase in penalty. And another important aspect is the compounding of offense. It is introduced through the courts. It is there in all the 4 courts. So for the first time, even if there is a deviation, if there is a non-compliance, there will be an officer specifically appointed for this purpose. The employer concerned can make an application to that officer, who in turn will compound this offense actually, which means the employer can make 50% of the maximum fine fixed for that offense. Then he can come out, but that will be available only for the first time, not subsequently. But this will not be available for those offenses for which imprisonment is mentioned as punishment, or imprisonment and fine. Only where fine is mentioned as punishment, there this is available. Yeah, I move on. I think with this we have come to an end of the key changes with respect to code on wages. Now we move on to occupational safety, health and working conditions code. First thing is with respect to factories. I think if there is a manufacturing process and if it is carried out with the aid of power, then 10 persons are required minimum to consider that premises as a factory. But if the manufacturing process is carried out without the aid of power, manually, then at least 20 persons are required. Only then that premises would be treated as factory. So this threshold of 10 and 20 is now getting increased to 20 and 40. So if it is done after the introduction of codes, with the aid of power, then there must be a minimum of 20 persons, right? Only then the Factories Act will become applicable. So this will be probably advantageous to the employers. And similarly, if the manufacturing process is carried out without the aid of power, then at least 40 workers are required. Only then that premises would be treated as factory. Then all the formalities prescribed under the Factories Act, we may have to follow as employers. Then the next point is engagement of women workers during the night shift, right? So beyond 7 p.m. in the evening and before 6 a.m. in the evening, that is what is considered as night time. If a woman worker in a factory is to be employed during that time, and the individual's consent is to be obtained as per the code, right? So there is a section, section 66(1)(b) under the current Factories Act, which prohibits engagement of women workers during this time, that is after 7 p.m. but before 6 a.m. Right? But Madras High Court in one case said this section is not constitutionally valid. Right? So only in Tamil Nadu, in factories, even today, prior to the introduction of courts, the women workers can be employed during the night time in factories without getting any special approval from the authority concerned, but it is not there in the other states, right? But through the courts, now the permission is given to engage women workers even during the night shift. Of course, certain formalities are to be followed. Specifically, the individual's consent is to be obtained, right? And for making a worker to do overtime beyond the normal working hours of the factory, the consent of the worker is required, be it male or female, right? That consent is required. And overtime, I think currently in a quarter, continuous period of 3 months, maximum 50 hours overtime can be done. But with the special permission, this can go up to 75 hours. That is the current position. But after the introduction of codes, it is made as 125 hours. In a quarter, now in a factory, a worker can work up to 125 hours as overtime, apart from the regular working hours. And independent director, you all may be aware, again, occupier is one important position as far as the factory is concerned. One of the directors in the board shall be made as an occupier, and this should be very specifically communicated to the authority concerned. But it should be the full-time director or the whole-time director. It cannot be the independent director. It is very specific. Even now, that is the position, but that is not expressly mentioned in the Act. But under the codes, it is very clear now. And for appointment of safety officer in a factory, if there are a minimum of 1,000 workers, then that factory shall have a safety officer. That threshold is coming down to 500. So now, that is after the introduction of codes, if there are 500 or more workers in a factory, then that factory should have exclusive safety officer. And welfare officer, the threshold limit is 500 workers. So if a factory has 500 or more workers, then that factory shall have one welfare officer exclusively. That number 500, that is coming down to 250. And the provision of canteen, if there are 250 or more workers in a factory, then the occupier of that factory shall provide a canteen for the usage of the workers. That 250 is coming down to 100. So on all these three aspects, the threshold limit is coming down, right? Now, yeah, so this is also with respect to contract labor, which is coming under the Occupational Safety Code. And major change, the first point, we all know again, under the Contract Labor Regulation Abolition Act, if there are 20 or more contract workers employed in an establishment, then the principal employer, for him, the act will become applicable. Similarly, if a particular contractor engages 20 or more workers under him, then the contractor, for him, the act will become applicable. So this threshold number of 20 is now getting increased to 50. Right. I think already 2-3 states have done this amendment. It is there in practice now. But after the courts, for all the establishments, only if there are 50 or more contract workers employed only then the contract labor portion, that part under the Occupational Safety Code will become applicable. Then I think whatever obligations prescribed for the contractor as well as the principal, they have to follow, right? Otherwise, up to 49, it is not required. Then the core activity is now defined. It was not there earlier. It was there only in Andhra Pradesh. But now I think this term core activity is defined, and contractors cannot be engaged for the core activity of an establishment. It prohibits, the code very clearly prohibits. And the contractor having operations in multiple states may obtain common license. See, this is there in practice even today, where the appropriate government happens to be central government, right? Not all are regularly practicing, but it is possible even today. But through the courts, it is formalized. And the principal employers have to provide the amenities to the contract workers. Currently, under Section 16 of the Contract Labor Act, the liability, responsibility lies with the contractor in the first place to provide amenities to his workers. Only if he fails, then the responsibility passes on to the principal employers, right? But under the codes, it is directly, the liability is lashed with the principal employer. So if we are engaging contract workers, then as principal employer, you may have to provide all the amenities without waiting for the contractors to do that. And interstate migrant workers, see, if a person is hired through a contractor in one state to be deployed in an establishment which is situated in another state, only that person will be considered as defined as interstate migrant worker, right? So when we say interstate migrant worker, he will be a contract worker in the first place. That is the present position. But under the codes, even the direct employees, so for my company, Aparajitha Corporate Services, I am operating in Madurai. If I recruit a person from different state, direct employee, then he can be considered as interstate migrant worker. The provider, his salary is less than 18,000. Whether it is contractor hired through a contractor or directly, if the salary of the individual goes beyond 18,000, then he will not be considered as interstate migrant. Only if it is less than 18,000, that person will be treated as interstate migrant worker. And if there are 10 or more such interstate migrant workers, then for that establishment, this ISMW, interstate migrant workers portion under Occupational Safety Code will become applicable. Workers from other states, this may discuss, even directly employed would become interstate migrant workers. In case of fatal accident or any other serious bodily injury to such interstate migrant worker, report is to be submitted to the authorities of both the states, his home state as well as the destination state. And provision with respect to payment of displacement allowance. Earlier, there was a provision at the time of displacement. That is first time when he comes out of his home state for employment in another state, some lump sum amount is to be paid to him, which is called displacement allowance. But it is removed under the code so that the employer need not pay that. But journey allowance every year that is to be paid, not only for the ISMW, but also to his or her family members. And they will also be entitled for public distribution system in the place of their choice. Either he can or she can get it in his home state or at the destination state. It is the individual's choice. And a toll-free helpline shall be made available for the interstate migrant workers. Again, free by the employer, but of course, the appropriate government has to come up with scheme for this. And yeah, so these are all again some common points with respect to Occupational Safety Code. Appointment orders made mandatory. So today, neither the Factories Act or any other labor law mandates the employer to issue appointment order, right? But it is there in some of the state-specific Shops and Establishments Act. It is not there in all the states. But through the courts, it is made as a mandate, right? Necessarily, it is more for formalization, right? It is the employment security for the individual concerned. So, but if in some company it is not done already, after the introduction of courts, this is to be done within 3 months, right? Yes, the rules are yet to be announced, but still the format is prescribed. probably for our idea, we can go through the provisions of the draft rules so that we will get an idea as to what are all the fields captured in that format to understand it. And third party audit and certification. Yeah, see, apart from the government officers, the government is planning to form a panel of experts, right? It is more to do audit, particularly with respect to the startup companies and other classification of companies which are to be mentioned in the scheme to be announced, right? So we have to wait for the scheme. So they will, on a regular basis, they will do the audit and submit the report to the employer concerned as well as to the government. So probably after studying it, the idea is government may come up with changes in the existing codes, amendments, right, on a continuous basis. That is the idea. And single registration, again, we do registration under PF, we do registration under ESI, registration under factory, registration under contract labor, under interstate migrant workers, under building and other construction workers. 6 registrations already we are doing separately. But after the introduction of codes, it is not required. It is sufficient if we have only one single registration under the Occupational Safety Code, right? And that will be utilized for other purposes also. Say, code on social security. You need not have separate registration under PF and ESI, which fall under code on social security. And daily hours, weekly hours, and other working conditions, so shall be fixed by the appropriate government. So the powers are given to the appropriate governments to some of the flexible items, since this subject is falling under the concurrent list. But of course, it should not exceed 8 hours. That is fixed by the central government. So if some state government want to fix it less than 8, it is possible. And weekly hours 48, rest interval at least half an hour, and spread over, it cannot go beyond 12 hours. When we say spread over, it is the regular working hours plus interval. Put together, it should not go beyond 12 hours. And in case of factory, if a worker works for 240 days in a continuous period of 12 months, then that worker will become eligible for leave to be availed in subsequent years. And it will be at the rate of 1 day leave for every 20 days of work performed in the previous 12 months, right? So for eligibility, he should have worked for at least 240 days. That 240 is now getting reduced to 180. So now, since the codes are already introduced, a worker in a factory will become entitled for leave if he completes 180 days of work in a continuous period of 12 months. And for factories, Contract Labor Act and BD and cigar establishment, we are getting separate license. Like registration, it is possible to get a common license, which is valid for 5 years after the introduction of codes. And in factories and other establishments, we used to provide amenities both for men and women separately, but from now on it should be provided for third gender also. So it is again a mandate. And health examination of employees who have completed 45 years of age. Whoever is engaged in a factory or a mine or a dock, or whoever is involved in building and other construction work. All those 4 situations, in fact, this medical examination is to be done by the employer. The cost is to be borne by him, and it should be done within 120 days from the first day of the calendar year, roughly so before April 30th. And proper records are to be maintained. What are all the records to be maintained? It is there in the draft rules. Yeah, I think appointment order we discussed. It is to be, I think, bold letters within 3 months. It should be issued within 3 months if it is not done already. Health examination we discussed. It should be done within 120 days, first to 120 days of the calendar year. Registration of established, we discussed again, it is going to be a single registration. So multiple registration will not be there after the introduction of codes. Yeah, I think we have come to the end of the Occupational Safety Code. I'll quickly rush on Social Security and the industrial relations. Again, the key points only. The first point is the proviso to the definition of the term employee, which says provided that for the purpose of Chapter 3, except in case of the employees Provident Fund Scheme, under Chapter 4. So Chapter 3 is PF under Code on Social Security. Chapter 4 is ESI. But when they say Chapter 3, it exempts employees provident scheme. So other than this, yes, pension scheme is there, EDLA scheme is there. That is included now, but PF scheme is excluded. So the term employee shall mean such employee drawing wages less than or equal to the wage ceiling notified by the government. Currently, we know that wage ceiling for PF is 15,000, right? And this will continue for some more time till such time new scheme is introduced. See, as far as PF, as far as ESI is concerned, after the introduction of codes, we need not make any change as of now, right? Till such time the new PF scheme is announced or new ESI regulations are announced. Otherwise, same thing only, but for the change in the definition of the term wages, right? But it appears when we go through the definition, particularly this proviso to the definition, the salary ceiling may not be available for the PF scheme members, right? So it will be available only for the EDLI scheme and pension scheme. But I'm not very sure that is the idea. We may have to get the clarity once it comes into force fully. And the next point is employees whose wages are more than the notified wage ceiling by the central government shall also be taken into account for determining the number of employees. See, this doubt will always be there in the minds of the employers. So because the number of employees required for the applicability of PF Act or scheme is minimum is 20, right? But for determining this 20, should we consider only those employees who are getting less than 15,000, or should we include people who are getting more than 15,000 also? I think that is cleared through the codes. Both the categories of employees are to be counted, irrespective of the quantum of their salary, right? Then the term employee specifically excludes apprentices under the Apprentices Act. In case if you in your company have the practice of engaging apprentices or trainees or learners, right, quoting some other purpose, I'm not very sure, some other your own policy, I wonder whether they will be considered as apprentices equivalent to the apprentices under the Apprentices Act. So they will not be considered as excluded employees. The authorities may ask you to cover these people also under PF. And again, there is a provision available under Section 17 of the Employees Provident Fund Act, which gives exemption to some of the companies if they make the application for maintaining their own trust, the PF accounts. But for doing that, minimum 100 employees, 100% should be there in the establishment, probably going forward after the introduction of the codes. Only those establishment can seek exemption under section. So practically it is not given nowadays, but still this is there in the statute book and it is there under codes also. So these are all these certain points with respect to PF. Otherwise, as I stated earlier, there is no change need to be made as far as PF is concerned. We can continue with our existing practice. And voluntary coverage is now ESI, right? Earlier it was there in PF. Now, yes, for PF it continues. In addition, for ESI also, now I think at least a minimum 10 employees are required. If an establishment has 10 or more employees, then the ESI Act would become applicable. But even if there are less than 10, if an employer and the majority of the employees in the establishment would want to get coverage under ESI, they can do so by making an application to the ESI Corporation. And if that is done, subsequently, if they want to withdraw that voluntary coverage, yes, they are also free to do that. And for plantations, yes, the employers of the plantations may opt for ESI. I think plantation workers ought to be extended medical facilities as per the provisions of the Plantation Labour Act. But if they feel that the medical facilities provided are lesser than what the ESI dispensaries do, then I think they can go for coverage under ESI. That is possible. And even if there are one employee is engaged in an establishment which is involved in hazardous or life-threatening activity, then the central government has got powers to issue notification to bring it under the scope of ESI. And for mines, currently, yes, the ESI Act will not be applicable, but after the implementation of codes, if there are 10 or more employees there in the mines, then like any other establishment. For them also, the ESI will be applicable. And in case of accident, while commutation between residence and place of employment, whether it is coming to office or going back from the office, that accident will be treated as employment injury, right? But if it is not so, then the otherwise is to be proved by the employer concerned. Otherwise, the default presumption would be it will be treated as employment injury. And in case if a particular employee is not covered under ESI, right? If the employer fails to cover an employee under ESI, or if covered, the contributions are not paid in respect of that employee, still the employee can go and avail the medical facilities, but the cost of which will be recovered from the employer concerned. That is there. Then gratuity, yes. So again, for gratuity also, at least 50% of the monthly gross salary would be treated as salary, and on that basis only gratuity is to be calculated. We all know the calculation is the monthly last drawn monthly salary divided by 26, which will give the per day wage, which is to be multiplied by 15, and which is to be again multiplied by the number of years of completed service by that individual employee. That continues, right? But here, at least 50% of the monthly wage shall be treated as monthly salary shall be treated as wage part for the calculation. And as we discussed for PF, apprentices under the Apprentices Act alone are excluded, right? Other persons would be treated as employees only. And another important aspect is the code allows the employers to go for fixed term workers. Normally, if we recruit a person today, then we may have to carry with that person till that person attains the age of superannuation, be it 58 or 60 or 62 or whatever. It can be fixed again by the organization concerned, right? But when we say fixed term workers, you can recruit a person for a specific period, say for 2 years or 3 years. It is possible. And after 3 years, yes, we can dispense with the services of that person. That will not be treated as retrenchment, right? So that provision is now available through the courts. But from the day one onwards, this fixed term employees would be treated on par with the regular employees, permanent workers. Right. And even if they work for, say, only for a period of 2 years or 3 years, they would be entitled for gratuity on a proportionate rate. Right. So it is not necessary that they should have worked for at least 5 years. That is for only the regular employees. 5 years of continuous service, that qualifying service period is available only for the regular employees. But for fixed term workers, they are entitled for all benefits which are available for the regular employees, permanent employees, but on a proportionate basis. And for working journalists, I think the minimum years of service required for gratuity is 3 years of continuous service. So for fixed term employee, 1 year is sufficient. For working journalists, it is 3 years. And for others, it should be at least 5 years of continuous service. Yeah, and other areas, again, common to code on social security, probably crush. Yes, if there are 50 or more employees, that is what the code says. But some of the rules, draft rules, if you go through, it says 50 or more women employees, probably depending upon as to who is your appropriate government. If the rules of that appropriate government is asking you to provide a creche only if there are 50 or more women employees, you can do so. Otherwise, irrespective of whether it is male employees or female employees, if there are 50 or more, then as employer, we may have to provide creche, irrespective of, again, the such establishment is covered under ESI or not. Yeah. Then employment information, chapter 13 under Code on Social Security. This we discussed again. This is the employment exchanges portion. See, if there are 25 or more employees, only for that establishment, the Employment Exchanges Act will be applicable. Here, the threshold limit is coming down. Instead of 25, it is going to be 20. Even if there are 20 or more employees, then for that establishment, this chapter 3 will become applicable. And as I said earlier, the employment exchanges would now be considered as known as career centers. And job seekers and job providers, they will have accessibility to a portal through which I think they can probably, whoever is seeking employment, probably they can get to become, probably they can make application to the job providers, or job providers, if they want people, they can get in touch with the job seekers. That is also possible using this platform. It can be a physical office or it can be a virtual platform. It is both are possible after the introduction of codes. And again, 50% of the remuneration shall be considered for working out compensation, particularly with respect to calculating compensation in case of accident under the Employees Compensation Act. As earlier, it was workman compensation. So at least 50% it should be treated as wages, like for any other purpose. And the presumption as to the accident, like again for as we discussed for ESI, for employment, employees compensation also, the accident while commutation between residence and place of employment would be treated as the employment injury. And yes, now the appropriate government for this term definition is available. Now, if you go through the Employees Compensation Act, the appropriate government is not defined. But since it becomes part of code on social security, the definition is now available. Probably the appropriate government, because of the definition, could change for your establishment. Probably we may have to, on a case-to-case basis, analyze and come to a conclusion. And yeah, I think next 2 points more important, but we have to wait for the schemes and the funds to be introduced. Social security for the gig workers or platform workers or any other type of unorganized workers. So the term gig worker, home-based worker, platform worker, self-employed worker, wage worker, it is all defined under the Code on Social Security. They will all be provided with social security. I think the aggregator will be made responsible. That is the idea. But of course, for implementation, we have to wait for the scheme to be introduced. And for ESI and PF, even if the enforcement officer notes some probably the contribution missing from the employer, whether in respect of the employer or in respect of the employees, they can proceed against the employer, but they can claim it only for the last 5 years, not before that. Probably in case if the person inspector comes for inspection today, November 2025, and if there is a default by the employer concerned, then he can go back up to say 2020, November 2020, not prior to that. Even if there is something pending which is not done, the employer, the enforcement officer cannot insist for that. Only for the last 5 years they can ask for it. And the role of inspector is changed to inspector cum facilitator. We discussed compounding of offense and increase in penalty. All those are there. Probably I would like to draw your attention to the last point, the application of Aadhaar number. Right. I think this particular provision is already introduced for identification. I think Aadhaar will be the base, whether it is for the employee or the family members of the employee. Right. So my suggestion would be at the time of recruitment, please get the Aadhaar copy of the new recruit as well as his first degree family members. Right. So in case of death of the employee, probably the amount is to be paid to the family members, for which again you may require the other details of the family members. Yeah. Now I think we move on to the Industry Relations Code. The term industry, I think this was discussed as early in 1978 in Bangalore water supply case. The idea is that must be a systematic activity, and that activity must be carried on with the cooperation of employer and the workers, and it should be for the purposes of fulfilling the human wants or wishes. If these 3 ingredients are present, then that place would be treated as industry. That is how it is defined. And there was an attempt to bring this into the statute book as early in 1985, but that was not true. So only now it is happening through the courts. I think they are bringing changing the definition of the term industry. But of course, practically, we go ahead whatever is pronounced under this case, Bangalore water supply case. And if the industry is for some domestic services, or the institution is for providing charitable or social or philanthropic services, those institutions will not be treated as industries, bringing them under the scope of any of the labor legislation, any of the codes, right? They are all excluded, right? And concerted mass casual leave, if more than 50% of the employees or workers go on strike, that will be treated as, go on mass casual leave, that will be treated as strike, right? I think the definition of the term strike now includes concerted mass casual leave. And if an employee resorts to willful go slow, that will be treated as unfair labor practice. So action can be taken by the employer concerned. And I think the last point is for getting permission for layoff, retrenchment. I think this is the very bone of contention by the various trade unions, because of which they were opposing these codes earlier, even now. So the minimum number required for resorting to layoff or retrenchment or closure by an employer is 100 under the Industrial Dispute Act. Now that is getting increased to 300, right? So I think this is one main point for which the unions were opposing. But yes, now this has come into force. And workers reskilling fund. So in case of retrenchment of an employee, yes, that employee will be paid a retrenchment compensation. Apart from that, 15 days wages of his last drawn salary, that will be deposited in a fund to be created for this specific purpose by the employer, right? So that fund will be utilized for reskilling of those retrenched employees so that they can be re-employed, right? That is the idea. Then the maximum number of members of the grievance redressal committee, it is increased from 6 to 10. And the notice for both strike and lockout, minimum 14 days notice should be there, and the maximum of 42 days, that is 6 weeks. That is the earlier position under Industrial Disputes Act. Now that 14 days minimum, that continues, but the maximum 42 days, it is becoming 60 days. So within the window of 14 and 60 days, they can resort to either strike or lockout. Strike is by the workman and lockout is by the employer. It is equally applicable for both. And the time period for filing a grievance application is reduced from 3 years to 1 year to the grievance redressal committee. And the time period for raising an industrial dispute, it is reduced from 3 years to 2 years. And finally, the standing orders and trade unions. So certification of standing orders, again, we all know the act would be applicable currently, the Standing Orders Act, if there are 100 or more employees in an industrial establishment, but that threshold is also getting increased to 300. And now only the central government will provide the model standing orders. Now, I think prior to codes, all the state governments also had it, but now it will be a common model standing orders. That should be followed before drafting the standing orders for a particular company. And if the application is submitted for approval of draft standing orders, but there is no response from the authority concerned for 60 days, then it will be considered that construed that the approval is given. So deemed approval provision is brought in. And fixed term employment, like we discussed for Code on Social Security, under Industrial Relations Code also, it is permitted. So the employers can now recruit person on fixed term. It is possible. And there is no provision for recognition of trade unions currently, that is prior to courts, but through the courts, the provision is brought in. So in case if there is only one union in a particular establishment, that needs to be recognized. But in case of multiple unions, the one union which has the support of more than 50% of the workers, that should be recognized. But if none of the unions has the 50% membership, then the employer is supposed to form a negotiating council at the rate of one representative for every 20% of workers, right? So there will be minimum of 5 persons. That 5 persons will form a negotiating council. and for any purpose, they will negotiate with the management for on behalf of all the workers. And again, as we discussed for other codes, the compounding of offence is also available under Industrial Relations Code. I think we have come to the end. Just at a glance on the code on wages redefined, there is a big impact. HRA is not treated as part of wages. Similarly, gratuity. Minimum wage would be applicable for all industries. Floor wage concept is introduced and it has statutory backup now. And those who are drawing more than 24,000 would also be coming under the purview of payment of wages, and salary is to be dispersed before 7th for all, irrespective of the quantum of employees in that industrial establishment. And deductions cannot go beyond 50%. Wage settlement is to be made within 2 days. And bonus ceiling, yes, it is to be fixed by the appropriate governments, both for eligibility and the calculation. And on the right side, it is the Occupational Safety Code, single registration, single license. Factory definition is changed. Instead of 10 and 20, it is going to be 20 and 40. Overtime, it can be done only with the consent of the individuals. Women workers, again, with their consent only, they can be engaged during the night time. And for a person to become eligible for leave, instead of 240 days, the qualifying period is coming down to 180 days. And the amenities are to be provided by the principal employer for the contract workers. It will not be with the contractor. And the threshold limit for the amenities like safety officer or welfare officer or canteen, the threshold limit is coming down. And the threshold for contract labor, it is getting increased from 20 to 50. And core activity is defined, and in the cannot be engaged, and the regular employees of contractors, they cannot be considered as contract workers. Interstate migrant worker definition is changed. Now the direct employees, if they are engaged from other state and if their salary happens to be less than 18,000, they will also be treated as interstate migrant workers. Appointment orders to be issued to all the employees, and health examination is now made compulsory. And voluntary coverage now possible under ESI. Mines brought under ESI scope. Qualifying period for gratuity for fixed term employees is 1 year. Working journalists is 3 years, and for others it is 5 years continuous service. And contract workers now eligible for gratuity. I think this is one more important aspect, because now under the code on social security, the term employee includes directly the contract workers also. And the gratuity is part of social security. So gratuity contract workers will also become entitled for gratuity post the implementation of codes. And to provide social security to unorganized workers, of course, for which we have to wait for the schemes to be introduced. And concerted mass casual leave will be treated as strike. Willful go slow will be treated as unfair labor practice. And time period for raising industrial dispute is reduced. Reskilling fund introduced. Threshold decrease for layoff, retrenchment, and closure from it is increased from 100 to 300. Fixed term employment, now it is possible. We can engage persons for a specific period. Compulsory recognition of trade union. So if no trade union, then at least negotiating council should be available, which should be formed by the employer. And these are all certain common items. Deemed approval concept is introduced. Compounding of offence is introduced. Maintenance of records, yes, it can be done electronically. Online submission of returns, applications, it is possible, but of course, they are yet to be fully ready. And the inspectors are now considered as inspectors come facilitators. So facilitation would come first. So in a nutshell, these are all the key changes under the codes which are introduced recently from 21/11/2025. Right, okay. Now, I think there are no subordinate legislation. There are no rules. We do not have central rules or the state rules. But next 1 month after the end of December, I think many of us as employers have to submit the annual returns under various legislations. So we may wonder as to how to proceed, because the rules are not available, but the existing set of 29 parent legislations now replaced by 4 codes, right? But in the absence, during the interim period, we can go ahead with whatever we have been practicing already, right? Say, for example, in case if you have to submit a form, a return under Payment of Wages Act, there could be a column called number of employees, where hitherto you would have counted the number of employees who were drawing less than 24,000, right? But under the codes, now that ceiling is removed. So irrespective of the quantum of salary, all the persons now becoming employees under Payment of Wages Act. So for filling up this column, you may have to consider all the employees. So content-wise, the return preparation is to be done based on the provisions of the already introduced codes. But you can continue to use the same formats which you have been already using till such time the new set of rules, be it central rules or state rules, are introduced, right? The information is, it will take another 1 to 2 weeks for the governments to come up with a new set of rules, and which will again be placed for passing it, and that will be there for 45 days. Then after that, after considering the suggestions received, they will come up with the final set of rules. That so overall, this will take another 3 to 4 months, probably March or April of 2026. So till such time, interim period, you can continue to use whatever forms you have been already using, right? So now, because the code on wages have already, all the 4 codes, they have already replaced the 29 parent legislations, but there are no subordinate legislations, rules available now, right? The current set of subordinate legislations, different types of rules, it is not yet superseded by any of the rules. So you continue to maintain the forms, templates prescribed under these rules, but for filling up the columns alone, probably you can lean on the new provisions under the codes. So that would be our suggestion to all the employers and all the participants here. I think with this, we have come to an end of this session. Once again, thank you so much for your patient hearing. I know you may have a lot of questions. Please share your questions, and I'm not very sure whether I will be able to take it up now. Subsequently, if possible, if you are sharing your mail IDs, then I can send it to you, because it is already 1 hour and 40 minutes, if I'm right. It's over to you, Shreya.
Hello, am I audible, sir?
You heard what I said, no?
Yeah, I heard what you said,
Okay.
sir.
Yeah.
And actually, there are many questions.
Sorry.
Yeah, there are many questions, sir. So we
Can we
should
take
be
up some
addressing
questions?
them
I'm
on mail.
okay.
Can we take few, or
Yeah,
you
sure.
suggest, sir?
Sure.
Yeah, I'll just take some questions. There is a question. What will be the impact of retrenchment and reskilling as part of final settlement? If we can share with an example.
Repeat the question.
What will be the impact of retrenchment and reskilling as part of final settlement?
No. See, retrenchment, once a person is retrenched, then he will be paid compensation at the rate of 15 days of wages for every completed year of service, like gratuity, but calculation will slightly vary, right? So payment of compensation, retrenchment compensation is one aspect. So he will be fully terminated from the services. But the last drawn salary of the individual employee who was retrenched, that will be kept as the base, and 15-day wages of the last drawn wage. Again, that quantum will be determined by the employer, and he has to necessarily deposit it to the fund. Again, that is to be created. That fund will be utilized for the purposes of reskilling those retrenched workers like him, so that they will become employable for later days. That is the idea.
Okay, understood. I'll take second question.
So now there is no creation of fund called reskilling fund. It is introduced through the courts only. That is the difference, actually.
Okay, understood, sir.
Hmm.
So I'll take one more question. Is journey allowance required to pay for ISMW workers, even if he or she migrates to destination state on their own livelihood purpose? Also, if exclusion part exceeds 50%, when any overtime payment include in a month, as OT allowance is included part, in an excluded part.
No, for the first part of the question, yes, they are to be paid journey allowance. Even originally, if they have migrated not for the employment purpose. The earlier position was not so, but through the courts, now even if they had migrated earlier for a different purpose, but subsequently in the destination place, they have acquired employment, they will also be treated as ISMWs, and yes, journey allowance is to be paid.
Okay.
And overtime need not be considered as part of wages.
Okay. Understood.
Yeah.
I'll take one last question, sir.
Yeah.
Just a minute. If leave encashment and bonus paid monthly, which can affect basic pay?
Leave encashment.
Hmm.
Number one, leave encashment shall not be paid on a monthly basis. It should be the decision of the individual concerned, and the individual shall be allowed to avail leave. And in case if he's not availing, it will automatically get accumulated. And as per the applicable legislations to that person, it could be Shops Act or Factories Act or any other act. Whenever the act allows the employer to make the leave encashment payment, then they can do that. It is not so on a monthly basis. It is not currently, it is not there. So payment of leave encashment on monthly basis will not arise.
Okay, sir.
What is the second one? Another payment, bonus.
Yeah, bonus.
Yeah,
paid
bonus again.
monthly.
Bonus is also considered to be an annual payment, and it is to be paid after the end of the accounting year, after deriving the profits. Based on that only the rate of bonus, whether it is 8.33, it should fall between 8.33 and 20. Right, based on that only it is to be paid. But the act very specifically allows some payment as customary bonus or interim bonus or bonus advance or festival bonus or puja bonus. That is allowed through section 17 of the current Payment of Bonus Act, that can be adjusted while dispersing the final year-end bonus. Otherwise, Act does not contemplate payment of bonus on a monthly basis. It is not a right practice, whether it is earlier Payment of Bonus Act or the courts. Position is same prior to or after the courts.
Okay, understood, sir.
Yeah.
So for the rest of the questions, we'll address it through mail.
Okay.
We have even received their email addresses and all.
I don't mind taking one or two more questions. if we are okay with.
Okay. Yes, sure, sir. If bonus is paid 20% to on-roll employees and 8.33 to contract workers, then after code.
What is the point? Sorry, 20% to regular employees and
8.33 to contract workers.
8.33% to contract workers.
Yeah.
Right. Okay. Right. See, prior to codes till 20th November 2025, contract workers are not entitled for bonus. Number one. From 21/11/2025, so for the part of this period, this can practically happen only after March 2026. They can become entitled for bonus if they had worked for whatever conditions mentioned in the codes. That is number one. And bonus is to be paid by contractor to them as employer. In case if the contractor fails, then the principal employer has to make the minimum rate of bonus payment to them. That is the position.
Okay.
So up to 2011-2025, contract workers are not entitled to.
Okay. There is one question. How are consultants, white collar, treated?
Consultants
or white collar people. So how are they treated in all this?
No. See, the white collar or blue collar, it is, these terms are used in the industries, but no law uses these terms. Right. This is number one. Okay. Number two, when you say consultant, so for my company, say I can say probably a doctor who is not an employee, totally an outsider, a professional. A doctor can be a consultant for me. An advocate can be a consultant for me. Similarly, a chartered accountant can be a consultant for me. Those are all outsiders and they are not bound by the rules and regulations of my company. So when we say consultants, actually these people are referred to as consultants. It could be even engineers or even other professionals, right? But in case if I am recruiting a person, giving consultant as a designation, then that person is a regular employee. It's a regular employee of my company. He's not a consultant technically.
Okay, understood.
Yeah.
There's one
so
more.
We need that clarification whether this consultant whom you are referring is the mere designation or real fact is they are all consultants. If they are really consultants, then there is no employer-employee relationship. If consultant is mere designation, then there is employer-employee relationship, and those persons will be treated as regular employees of the company only.
Okay, understood, sir.
Yeah.
There's one more. Does attendance bonus or attendance incentive from regular salary component shall be considered as wages?
Attendance bonus. It is not a regular payment, no. It is a contingent payment. So it will be excluded.
No, but if you're saying if it is an attendance bonus, it might be for every month they would be getting certain bonus for their attendance, right?
No. See, I think whoever has raised these queries may have to explain the position. When you say attendance bonus, I understand then there must be some regularity which the individual should fulfill. Only then that person will become eligible for this payment, whether it is attendance bonus or attendance incentive. Or is it merely paid like any other component? If that is like that, then it will be treated as wage.
Okay.
If there is a condition attached for becoming eligible for this payment, then yes, it is a contingency payment. It need not be treated as part of wages. Otherwise,
Right.
yes, it is wage only.
Okay.
Somebody is
This,
asking, is reimbursement part of wage? Reimbursement is not part of
yeah.
wages, but it should be truly reimbursement. That is the catch.
Okay.
There must be proper vouchers, bills to support that expenditure.
Understood.
Yeah.
There's one more. How is that possible to calculate the bonus by PE as the PNL is of contractor?
Come again.
How is that possible to calculate the bonus by PE? I think this is principal employer.
Employer. Okay.
Yeah, as the PNL is of contractor. Profit and loss sheet is of contractor.
That is
I
why
think.
I said contract workers are not eligible for bonus. That is the position very clearly till 2011-2025. Right. But 20 up from 21-11-2025, the position is slightly changing. Still, principal employer is not liable. Right. But the contractor has to pay the bonus. But if the contractor fails, the principal employer to make the payment, but which should be the minimum bonus payment only, not more than that. So it is not based on the P&L account of the principal employer. It is just they are latching the liability on the principal employer to the minimum extent only.
Okay, understood. So,
yeah,
there's one more where they have said that the PF we are following is 1800 as minimum contribution for both employer and employee on monthly basis. Will this be allowed in the new codes?
15,000 saving will continue.
Yeah, 15,000 will be with that ceiling will continue.
Okay.
See, if you say 18,000 is the PF wages, now the choices with the employer only. They can continue to pay PF contributions on the 18,000, or they can restrict it to 15,000. Both are possible, and that position is available even after the introduction of the codes.
Okay. Should I take few more questions?
Maximum 2.
Okay, maximum 2.
We see
Yes,
one query. Do we need to restructure salary immediately as per the new wage code? So we discussed on the definition of the term wages. So if the wage portion is less than 50% in the salary structure, then we would suggest to restructure to make at least the wage portion touching 50%. Otherwise, there could be a difficulty in ensuring compliance from all perspectives. Somebody is asking the changes would be applicable to shops and establishments. I think I said in the beginning, the changes are happening only with respect to central laws. For those establishments covered under Shops and Establishments Act, I think that would continue to be the governing legislation. Of course, certain portions like contract labor, ISMW, all those things would be applicable. That is there.
Okay, sir.
Yeah.
I'll take one last.
Yeah.
Whether the construction workers under buildings and construction workers will continue to be exempted from coverage of ESIC scheme post the notification of 21st November under the labor codes.
Construction workers. They are to be covered under ESI
Under
or not?
the
No. case specifically project, they are direct workers if they are otherwise eligible.
No, same position continues. As such, it is not, they are not coverable.
Okay.
There will be two categories of persons actually. Construction company, if they have their own employees, for them it will be applicable. Again, the position is same, whether it is prior or after the course. But if they are hiring persons locally, specifically for that project, then I think those persons need not be covered under ESI. Again, same position, prior and after.
Okay.
Yeah.
Understood, sir.
Yes.
So that's it. And rest of them will answer it through mail, sir.
Okay. Probably you can forward those questions, no? If we
Sure.
are able to take it out, then if the emails are available, then we can share it with them.
Yes, sir. We have maximum of them here, email addresses. So we'll address to everyone, sir.
Okay. Right. Okay. Yeah.
Thank you, sir, for
Thank
the
you.
session.
Yeah. Thank you.
Thanks. Thanks, everyone.